In this case is State versus McAusland, I believe. And the appellant may have up to 5 minutes, up to 15 minutes altogether, but up to 5 minutes for rebuttal. And you just have to let me know if you want to save some time, Mr. Lorenzen. And sure. Excuse me. And then, and obviously the appellee will have the 15 minutes afterwards. So would you like to reserve some time?
Yes, Your Honor, please.
Okay, how much time would you like?
5 minutes, Your Honor.
Okay, and we are just a minute early. Is that okay with everybody just starting a little bit early?
Sure.
All right, thank you.
Certainly.
You may proceed.
Thank you, Your Honors. May it please the court, my name is Attorney Jason Lorenzen, and I represent the appellant, Mr. James McAusland. I want to attempt to keep my argument quite simple because I think that there's two things I'm going to rely on, obviously the statute and two cases. But a couple of things I want the judges to remember. It's 9,284 days. That's the time that it took for Mr. McAusland to realize that he had an immigration consequence back in 2019 for something that he pled to in 1994. He came, as stated in the briefs, but I think it's important just to underline, he came to the United States as a minor in 1969, lived in the United States ever since. Never, I think he left the United States once when he was young, always remained in the United States until his deportation last year at the end of the previous presidential administration. He knew no other place. But again, I want to keep the law simple. In 1994, Section 236C of the Immigration and Nationality Act was in existence. And it states, a bit of a paraphrase here, but it states, upon release from custody, immigration shall detain and take into custody an alien subject to mandatory detention. The two convictions, there's no doubt that they were aggravated felonies for immigration purposes. Aggravated felonies simply mean in the immigration context that the person is subject, the alien, the foreign-born, is subject to mandatory detention and is subject to deportation and removal from the United States. Mr. McAusland was sentenced to 5 to 15 years, a definite sentence, but yet shock release was granted to Mr. McAusland, and he was released into custody. And this was back in after 8 months after sentencing, and immigration was under a duty under INA 236C to meet him there. But immigration was not there. They were not waiting for him, and he was released back into the general public.
Counsel, is there anything, and I only want you to refer to things that are actually in this record before us. Was there anything in the record as to what caused the delay in immigration notifying him?
Unfortunately, the only thing that's in the record, again, there's a certain amount in administrative laws, I'm sure the judges are well aware of, there's a certain amount of discretion that's left up to immigration. What's the biggest issue, the biggest proof that was submitted to the court, definitely to the trial court, and it should be in the record, I'll double check that, but I'm pretty sure it's in the record, is a notice to what the document called notice to appear, which was issued sometime around, I believe it was September 18th or 19th, 2019. That's the first time he became aware that the 1994 conviction would result in immigration consequences. Now
he did have another offense, a misdemeanor offense, that he was notified that he could be deported over that. And that was, when was that? 2004?
That was in 2004, Your Honor. And this is where I think the trial court, respectfully, I think the trial court was getting confused on that issue. Each criminal matter should be taken separately. In particular, 2004 was also post 9/11. Our regulations were being more strictly enforced. And that particular conviction again, ask you to take judicial notice of this, would not result in removal from the United States. Although the advisements were given, separate case, different case, but those advisements, and our position is those advisements under 2943.031A especially should have been given as well in the 1994 plea deal, this plea colloquy, which there's obviously no proof in the record that was done, conceded by the state and as well in the trial court.
Go ahead. I'm sorry. No, you go ahead and finish. I'm being rude. I apologize. Go ahead.
No problem. In the trial court's decision that was mentioned as well.
Mm-hmm.
So I
was going to say, but the reason why it's not available is because of the long time period. The court is not required to keep the transcripts.
Correct. And then obviously there's that presumption that the court shall set aside the judgment and permit the defendant to withdraw a plea of guilty if the court fails to provide the defendant with that advisement. And there's no proof, and there's a presumption that there isn't proof. There's a presumption that the advisement wasn't given. And this court, bringing the attention to this court, you decided a case called HTOO, HTOO, quite recently, where timeliness in the 2943.031 advisements, there was no proof in the record that they were given. And again, very similar set of circumstances, that similar paper record, that record of proceeding that was initialed by that particular defendant, HTOO. But nevertheless, this court decided that wasn't enough and remanded the case back to the Stowe Municipal Court for further deliberation on that matter. But again, there's no, and I think the state does concede that there was no evidence in the record that those advisements were given. And I think that's the key issue here. And I'm trying to keep this simple, is to focus, what I ask the court is to focus on the requirements of 2943.031, which is in effect since 1989. And that the idea of the presumption in 2943.031E, that if there is a presumption there that if there's no evidence in the record, that presumption that advisement wasn't given, be especially considered in this court's deliberation, since the no record does exist. And the bigger question is, is there any evidence in the record that the court substantially comply with 2943.031A? And again, was that advisement given? And I think that the state and the trial court judge did say that there was no record of that. And now, to overcome that presumption, yes, the state did produce a waiver of rights. And I think you've addressed that in matter of HTOO, which is, again, binding in the 9th District, which was a misdemeanor case. But again, there was this sign of waiver. Did the court go any further? And I think the issue with the state and the trial court, the state was arguing that there's an issue of timeliness. When should Jim or Mr. McAusland have known or knew that he would have an immigration issue with a 1994 conviction? Again, 9,284 days. Yeah, that's a substantially a long time from 1994 to 2019, where the person's living a life in the United States, getting green cards renewed, not having any issue. And and again, I asked the court to take judicial notice, with change of any administration to another presidential administration, policies do change. If this was to occur today, do I think we would be here today? Probably not. I don't know. But again, that's a hypothetical I'm throwing out to the court. But I think where the bigger issue is where the trial court did get caught up into the idea of timeliness. And again, 2943.031, the court failed to provide, the four-pronged test. The court failed to provide the warning. The warning was required. The defendant is not a United States citizen, and the conviction may result in deportation, exclusion, or denial of naturalization. And again, I think the timeliness is answered because Mr. McAusland did not know until he was put into removal proceedings, apprehended by Immigration and Customs Enforcement on a day in September 2019. Again, was there any warning? Why did it take the administrative agency so long? Because they can, upon release, even though that language is very stated very succinctly in the Immigration and Nationality Act, upon release is coming in under the Board of Immigration Appeals, again, asking you to take judicial notice of that. They can do that at any time after release. So it could be, and I've dealt with cases 35 years ago, in this case, 25 years ago. And again, a lot of it is on which administration is in the White House and the executive agency. But
and counsel, you're beginning your 5-minute rebuttal.
Okay.
Do you want to save that, or do you want to
I will
proceed?
save that.
Okay,
I will save
thank
that,
you.
Connor, so much.
Thank you. Mr. Murphy.
Thank you. Good morning, Judge Carr. Good morning, Judge Callahan. Good morning, Judge Teodosio. This is an appeal of the trial court's judgment denying Mr. McAusland's motion to withdraw his guilty plea under 2943-031 of the revised code and 32.1 of the criminal rules. The one observation I'm going to generically and generally make here is that what you heard during appellant's initial oral argument, there's a lot of things that aren't in the record, a lot of things. No one testified from any federal agencies. No one testified regarding presidential administrations.
Mr. Murphy.
Yes, Judge.
Just like I told him, anything that's not in the record, we're not going to be able to consider anyway.
Certainly, and I just wanted to point out these things.
Thank you.
The other thing I'd like to point out is that the only case that's before this court is the underlying common pleas case of 93CR043678. 044050 is not properly before this court. It's not before this court because it was not properly perfected as an appeal. So any references within Mr. McAusland's brief regarding sex offenses, the underlying facts about sex offenses, and the family-related victim are not properly part of the record because it was not appealed properly. The state believes that it's equatable, however, to 404B evidence as part of these proceedings. I kind of put it on those same lines in that it goes to Mr. McAusland's state of mind, given some of the intervening circumstances or intervening events, which I think is the state believes is the most critical point of these proceedings, were the intervening events in 2004. Specifically,
Counsel, I'm sorry. I read that in the briefs, but I want to make sure I understand exactly what you're saying. So you're saying 44150 was the sexual offenses that were convicted of sexual offenses. And he did file a motion to vacate in his plea in regard to those, but that has not been appealed properly.
Correct, Judge.
Okay. And then the 43678 is the burglary, or attempted burglary.
That's correct.
Okay, thank you. I just was a little confused. I appreciate it.
Absolutely. So again, going back to intervening events, intervening circumstances, Mr. McAusland pleaded no contest and was convicted in Cuyahoga Falls Municipal Court, which I actually don't believe exists anymore. I think it did combined with Stowe Municipal Court into one. But nonetheless, the no contest plea featured in that documentation what's essentially the 2943.031 advisement of the revised code. So as far as, and that was a sex offense, a sex-related offense, typically public indecency. And so the argument is, look, if Mr. McAusland was advised that some fourth-degree misdemeanor offense subjected him to potential removal from the country, then certainly he should have realized at that time that that he was subject to removal for felony offenses that he had been convicted of some decade prior and actually gone to prison for. The other is that Mr. McAusland's brother had been deported for one of the offenses that he was also that Mr. McAusland was convicted of. And as I noted, although it doesn't go directly to a burglary charge, the fact of the matter is that if Mr. McAusland's brother had been removed for felony offenses, then he too should have realized at that time that he could have been removed to or at least sought counsel about, if he indeed hadn't been advised of potential deportation, immigration consequences of his convictions. He should have at least sought counsel about whether he could be removed too. The state concedes that there's no evidence in any record. Obviously, there is no record here, and that's Mr. McAusland's fault. It's his fault that there's no record in that he took so long to bring these motions. Had he brought them in 2004 or 2005, we very well might have had a record that supported the state, that undermined or nullified his allegation that he was never given the immigration advisement. The cases that are more on point, and you know what, I need to tell this court that the 2 case, HTOO, is not even cited in his brief. But let me respond to it because I did read it in putting together the state's brief here. And what I point out is that all the cases that Hattu's based on the trial court's referral to its own personal notes and that really was the grounds that this court found for the court's abuse of discretion. And that was also the same reason there's 2 cases that the court relied on in coming to that decision. One a 1966 10th district case, the other a 1966 case also, in which judges relied on personal recollections. Another one in which the first one, there was a lack of confrontation, I believe is what my notes sort of indicate. An impartial tribunal basically is what that 10th district decision rested on. So that's not, those cases are distinguishable. Hattu's distinguishable. The judge here didn't rely on any personal recollections. In fact, he wasn't even the trial court judge, obviously, in 1993. He was a visiting judge, in fact, so he didn't even have a direct relation to this court. The cases that the state cites, Razzo and Liu, actually undermine Mr. McAusland's argument here that each case should be taken separately. In those cases, this court looked at some intervening cases that happened after, of course, the cases in which Razzo and Liu were attempting to withdraw their guilty pleas. This court looked at, in 2003, a transcript existed in the Razzo case. And therefore, this court said, look, we're not going to let you withdraw your 2002 guilt pleas because in 2003, you were advised, and the transcripts show that. With regard to the prejudice, the state frankly, the assignment of error that Mr. McAusland gives is just incorrect. The trial court did not place any heightened focus on prejudice. First of all, prejudice is encompassed with the timeliness, which is why the state encompassed so much prejudice here. We don't have a trial record. What happened was the situation turned really urgent for Mr. McAusland, and therefore he decided to try to withdraw his pleas here. That's what happened. I don't think we're going out on a limb to say if he hadn't been removed, if removal proceedings hadn't started, he wouldn't have tried to withdraw his plea. But that's what the court really said was, look, the trial court said, it's the possibility of being removed from the country that you're advised of. It's the possibility that you were advised of in 2004. And with that possibility, if it was that much of a concern that you weren't advised and you would have done something different, then you should have done something different in 2004, not 2021 or 2020, when the state is highly prejudiced by a lack of records, potentially having to take a nearly 25-year-old case to court with a victim who's now an adult and was at the time a teenager.
Let me interrupt for a second. Let me just ask you, when you mentioned the victim, I don't remember motions, right? Was there a hearing, an actual evidence?
There was a hearing, Judge, at which some evidence was admitted by the court. The state, in fact, has supplemented the record. I'd like to point out with some of the evidence.
Right. I remember that now.
But there was no testimony by anyone, Judge. No one was placed under oath and testified. Some affidavits were admitted as far as testimony.
Is it in the record whether the victim was notified of this hearing?
Oh, absolutely. The victim's affidavit was admitted as evidence, first of all. And secondly, I believe the record would also indicate the victim was present for the hearing. At least the judge's decision notes she was prepared to testify if necessary.
Thank you.
And frankly, look, the trial presentation, if the state would have had to do it, which the court said, the state did incur prejudice, but not to the point of precluding conviction, which of course presupposes a prosecution. Look, was a prosecution possible? Certainly, but a prosecution based on 1993 facts, early 90s facts, is a lot different than a sex offense prosecution looks in the year 2021 to a jury. With regard to the 32.1 criminal rule 32.1 discussion, the manifest injustice it really should be predicated on the ineffective assistance of counsel. But there's no evidence in this record of ineffective assistance of counsel, but that's because there is no record. There's just really bare bones assertions made in the motion that don't even come from Mr. McAusland's affidavit, frankly. And the fact that 2943.031 was not complied with, which we presume, we can see that we have to presume that, can't support a 32.1 criminal rule argument. Either 2943.031 stands on its own, or 32.1 and is successful. 32.1, the criminal rule, rests on counsel's failings. And Francis makes that clear. The General Assembly did by saying 2943.031 gives you a different means, a different vehicle for withdrawing a plea than 32.1. So they can't be interlocked together. If the court doesn't have any further questions, the state just asks that you affirm the trial court's judgment to deny Mr. McAusland's motion under both 2943.031 and 32.1.
Thank you.
Thank you, judges.
Thank you. And Mr. Lorenzen, you have 5 more minutes.
Thank you, Your Honors. I just want to correct a couple things that Mr. Murphy said. HIT 2 is cited in the appellant's brief, and it's at page 11, Your Honors. And this is kind of the issue that we were facing with in this entire case. It was extremely difficult, and I know it's not on the record, but I want to put this before the judges. This was during COVID. It was a very difficult time to practice on Zoom as this is, although I'm grateful to technology. However, notwithstanding that, again, the state seems to rely a lot on 2004 and the waiver that Mr. McAusland signed. Again, my concern is the constitutional protections that a defendant has in a criminal case that were obviously not, especially 2943.031, not, well, at least there's no evidence that they were even complied with. The trial court judge, my question is, why didn't the state call the trial court judge to testify? My understanding, again, he's still around. The prejudice to the state, from what I also understand, is that the victims are still around. Most of the victims are still around, although it is, we'll concede that it would be more difficult to try a case 25 years later. And that's what this court really has to decide, weighing the state's interest versus the criminal defendant's constitutionally protected interest, as well as the statutory substantive right that he has under 2943.031. And also the state brings up Razon and Liu. Again, I believe that those are distinguishable. Hatu, I think, is again more on point to this case. But again, something that happened in 2004. How that's entirely different. That particular court, did protect Mr. McAusland's rights by doing the compliance of 2943.031. Yet we don't have that in the 1994 case. That's something
But counsel, I understand your argument that the 2004 excuse me, that the 2004 notification is irrelevant to the 1994 case. But at least in 2004, which would have been 15 years before, he was notified that an indecent exposure misdemeanor case could subject him to deportation. At that point, couldn't the trial court consider the fact that, in regard to timeliness, that it would have been placed on his radar, that this is a possibility?
No, I disagree with that, Your Honor, because again, given the complexities of immigration laws and how fast they change, with regards to that, again, each case has to be taken separately. It's in the record, the notice to appear. You will notice that there is no charge from 2004 rendering him removable. Again, there was nothing that happened right after 1994, 1995. The state also brings up his brother, totally different case, totally different set of circumstances. Again, I can't recall if they mentioned that in the brief, but again, very different sentence, very different outcome. Again, I don't think you can compare apples to oranges in this case. I think this court, this panel has to take a look at whether 2943.031 was complied with, where the defendants constitutional and substantive statutory rights complied with and protected by the court. And honestly, he did not know that this was going to be a problem until 25 years later. And he did everything from that point on. Our position is he did everything that he could and was required to under the law. And because he knew or should have known, according to the state in 2004, we disagree with that. He knew or should have known in 2019 when he was given the notice to appear to act accordingly. And
Counsel, thank you. Your time is up.
Thank you, Your Honor. Thank you.
Thank you very much. Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as, obviously, you can check our website and the Supreme Court website for our electronic release of the opinions. Again, thank you. Now, my understanding is we're going to be going, this session of court will end, and we are going to be going off the record, and there are some students that have some questions to ask us. Mr. Murphy, you're more than willing to